Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Let's start off our week with Judge West. The Monday morning fashion show has begun.
Hired.
No, I did visit.
Who'd you talk to?
I talked to Kendra, Miss Holmes, and Attorney Adams.
Okay.
And he did state, Attorney Adams did state if he was elected that he would represent me pro bono.
Okay. So, well, what do you mean if he was elected? I don't.
Well, if you assigned him to my case.
Oh yeah, it doesn't work like that.
Okay.
Okay. So are you working?
No, ma'am.
Okay. Why aren't you working?
I'm retired and I only have one source of income, and that's Social Security for my husband's death.
Okay. All right.
And
So
I do have cancer.
okay. So what I'm going to do this morning, Miss Graham, is have you fill out some paperwork. Thank you for doing what I asked you to do. To see if I'm going to have you fill this paperwork out to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Don't leave it all blank or put zeros. And then I'll take a look at it when you're finished. If you'll step over in front of the clerk, she'll give you that information.
Yeah, actually, about the monitoring situation, if I can be relieved from that.
Let's take care of this first,
Yes,
okay?
ma'am. Did you need the
Good morning, Anna.
Okay.
Joan Kraus. Good morning. Are you Joan Kraus?
Yes, ma'am.
And Ms. Kraus, this is your initial appearance in cause number 25, DCCR 0904. You're charged with a third-degree felony offense of driving while intoxicated, third or more, from July 16th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I got a court appointment.
Right. So when you're in custody, we automatically give you a court-appointed lawyer. If you make bond, I expect you to at least try to hire your own lawyer. Are you working?
No, ma'am.
Okay. Why aren't you working?
Retired.
Okay. And so you have a retirement income?
Yes, ma'am.
So what I'm going to do, Ms. Kraus, is reset your case to give you some time to try to hire a lawyer. Okay. You need to, if you get someone hired, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
I do, ma'am.
And are you, do you have the ignition interlock device on your vehicle?
No, ma'am, I don't have one.
You're not driving. I want to make sure you understand it's a condition of your bond. You cannot drive unless you have that on your any vehicle. Do you understand?
Yes, ma'am.
Okay, step in front of the clerk. She'll give you your reset notice. Sarah Henderson. Good morning. You're Sarah Henderson?
Good morning, yes, ma'am.
And Ms. Henderson, did you get someone hired?
No, ma'am. I got 3 people, but my income hasn't changed. So I'm trying to see if I can maybe qualify.
Who'd you talk to?
I talked to Langston, Scott Adams, C.L. Swisher, and Kippy French.
Mm-hmm. Okay. And what do you mean your income has changed?
Well, I switched jobs and I'm making a little less. You know, but at first I was making too much to get one the last time I was here.
Mm-hmm.
But I'm trying to see if maybe I'll qualify to get a court-appointed lawyer now.
Why did you switch jobs to make less money?
Well, I didn't really have a choice, you know, so
Okay.
I didn't want to switch.
Where are you working?
The city of Ohio,
Okay.
streets and drainage.
Okay. So I'll let you go ahead and fill out that paperwork again. Make sure you fill it out accurately and completely, just like you did last time, and then I'll take a look at it. Okay? Step in front of the clerk. Janisha Jackson.
Doesn't apply, the application, don't just hit apply. And go to the-
Good morning. Are you Janisha Jackson?
Janisha Jackson.
Janisha, and Ms. Jackson, this is your initial appearance in cause number 25, DCCR 0903. You're charged with a second-degree felony offense of abandoning or endangering a child, and that's from May 26th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, not yet.
Okay, so what I'm going to do, since you've made bond, is I'm going to give you about a 30-day reset to give you some time to try to hire a lawyer. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Yes,
Do you understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice. Presley Viltz. Good morning, you're Presley Viltz. And Mr. Viltz, did you get someone hired? Who'd you talk to?
Scott, King,
Speak up, please.
Scott, and
I can't hear a word you're saying.
Kimberly, James.
James who?
Nathan.
Okay. So where are you on being able to get one of them hired?
I just started getting back on work.
Okay, where do you work? Say?
Court.
Okay, so what I'm gonna do, thank you for visiting with those attorneys. I'm gonna give you one more reset, see if you can get some funds together to hire one of them or anyone else. If you get them hired, bring that reset notice. If it's not gonna work out with one of them, talk to 3 others, bring me those names, and we'll discuss your options if we're still unable to hire someone, okay? So make sure you talk to 3 others if you don't get somebody hired. All right, step in front of the clerk. Crystal Latulas. Good morning, ma'am. You're Crystal Latulas. And Ms. Latulas, this is your initial appearance in cause numbers 25 DCCR 0850 and 0851. In each of those cases, you are charged, sorry, give me a second, with the second-degree felony offense of abandoning or endangering a child, and that's from May 30th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
This is the thing, Judge Lewis, I'm gonna be honest with you. My child, when I got out, I had no stipulation.
Speak up, please.
When I got out, I had no stipulation, right? So the week that I got out, I got a call and she said that the child had to be removed from the home. I'm a parent at the end of the day. I have a nursing license interfering with this charge that I have now. That was my whole point of starting over. I already had got my nursing license, but I'm going.
Okay, you're telling me way too much information.
Okay.
Here's the thing.
I was just asking about my child. Is there any type of way that I could get?
You need to get a lawyer, and they can file a motion asking, but just with your word, based on what you're charged with, no, I'm not going to allow that at this point, okay? So I'm going to expect you to try to hire a lawyer, reset your case about 30 days to give you some time to do that. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talk to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Okay.
Do you understand?
I don't. He told me something about the version we just stepped out.
Okay. That's why you need to go hire a lawyer, okay?
Yes,
Step in front of the clerk. Lisa White. Good morning. Are you Lisa White? And Ms. White, this is your initial appearance in cause number 25 DCCR 0923. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from May 24th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am, I talked with Mr. Alvin Samuel,
Uh-huh.
and he suggested the price, and that's really important.
Okay, perfect. So what I'm going to do, Ms. White, is reset your case about 30 days to give you some time to try to either get Mr. Samuel hired or anyone else. If you do get him or someone else hired before the next court date, just bring that reset notice to them. They'll tell you what to do. If you're unable to hire someone or if it's not going to work out with him, then I'm ordering you to visit with at least 3 other attorneys and bring me those names so I know you're trying, okay? All right, step in front of the clerk. She'll give you your reset notice.
Good morning once again, everybody. Again, happy Monday. Welcome to the Courtroom Files Live. I'll keep an eye on the fashion show. Let's go down to Miami and see how much partying they did over the weekend.
It is probable cause for strong arm robbery.
¿Existe motivo fundado que justifica el cargo de robo a la fuerza?
You are ordered to stay away from the alleged victim whose initials are DM.
Señor, tiene prohibido acercarse a la presunta víctima cuyos iniciales son DM.
No contact with that victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Tiene prohibido comunicarse con esa persona que sea de manera directa, indirecta, por escrito, por teléfono, por mensaje de texto o a través de terceros.
And you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times.
Además, tiene prohibido aproximarse a menos de 500 pies de la víctima en todo momento que sea, donde viva, donde trabaje, donde estudie.
Okay, all right, thank you. All right, so I'm setting a bond at $7,500. Have a nice day.
Aunque la fianza es de 7,500. Buen día, señor.
Next is Yoandres Q, page 13. I don't know what the reset date was, I forgot. It's a calendar. Mr. Robles.
On Mr. Martin Cardona, would Your Honor consider house arrest for this case? He does not have the funds. Apparently got pretrial in the other case.
No, he was the one. Was it? No, he's the one who took the bike, no. With force. I'm not giving house arrest.
No, sí.
Now we have Mr. Yoandres Q. Where is he?
Wait, where's, oh, I had Mr. Fernando Hernandez.
Huh? I don't
The
know
one-
who he is.
Between Mr. Martin Cardona and Mr. Q.
Did I give you one back? Because I don't see that. What number is he?
He's
Okay.
number 41.
Thanks for now. What page is he on?
It's on page 13.
Good morning, sir. You were arrested for false imprisonment and aggravated battery on an elderly person.
¿Es de Spanish?
Yes.
I don't know.
Buenos
Spanish.
días, señor. Usted fue arrestado por privación ilegal de libertad y por agredir a una persona de tercera edad.
I will appoint the public defender's office for you.
Queda designado un abogado de oficio.
There's probable cause for the charges.
Hay indicios de criminalidad que justifican estos cargos.
Sir, you are ordered to stay away from the alleged victim whose initials are BK.
Señor, tiene prohibido acercarse a la presunta víctima cuyos iniciales son PQ.
No contact with the alleged victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Señor, tiene prohibido comunicarse con la presunta víctima, que sea por teléfono, por mensaje de texto, por escrito, en internet o a través de terceros.
No contact with the victim through social media or other electronic means.
Igual le queda prohibido comunicarse con la víctima usando el internet o otros medios digitales.
And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Además, tiene prohibido aproximarse a la víctima donde viva, donde trabaje, y eso le vale en todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
Le queda prohibido cometer actividad delictiva, igual le queda prohibido consumir sustancias.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Igual queda prohibido portar o tener arma de fuego o municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Cualquier arma o munición o permiso para portar armas de manera oculta se debe entregar a la policía, a la comisaría más cercana, y debe presentar un comprobante de dicha entrega a la secretaría.
And you may return to the victim's residence one time only within 48 hours of your release from jail.
Y además, señor, se le permite volver a la vivienda en un plazo de 48 horas al salir de la cárcel, portando la orden, y debe ir únicamente acompañado por la policía.
If you go to the victim's home without the police, or if you stay there, you will be arrested.
Si acude a la casa de la víctima sin venir acompañado por la policía, terminará de nuevo en la cárcel.
Do you understand the stay away order, sir?
¿Entendió la orden de alejamiento, señor?
Anyway, I'm
He's-
granting the state's
He's not
motion.
a no, Judge.
You don't
Um,
understand the stay away order. You can't
there-
go near the victim. You broke her
there-
arm. You pushed
There
her.
may be some issues, Judge, based upon page 2, the last paragraph.
No entiende la orden. Usted le tiene prohibido acercarse a la víctima, le rompió el brazo, la empujó.
You gotta stay away from the alleged victim.
Señor, tiene prohibido acercarse a la presunta víctima.
Anyway, you'll see a judge tomorrow. I am granting the state's motion for pretrial detention pending final hearing.
De todos modos, va a comparecer ante el juez a cargo de la causa mañana. Concedo la petición de la fiscalía pidiendo prisión preventiva.
I
Judge,
have-
would you consider setting a bond? I don't see any prior history of any acts of aggression.
¿Sería posible dejar de salir bajo fianza? No veo actos previos de una conducta violenta.
So in this case, he pushed the victim to the ground. He put a sofa in front of the door so she couldn't leave. And the victim, who's 75 years old, sustained a broken wrist.
Pues en este caso la empujó a la víctima, la empujó al suelo y luego colocó él un sofá delante de la puerta para que ella no pudiera salir. La víctima, de 75 años de edad, sufrió una lesión a la muñeca a causa de esto.
All right, so I cannot give him anything other than I'm sorry, I cannot release him. I'm holding him with no bond. He'll see the division judge tomorrow. That judge can set a final hearing or decide he should get a bond or house arrest.
Así que no se me permite a mí dejar que salga. Él va a comparecer ante el juez a cargo mañana, y ellos van a decidir si se le permite salir bajo arresto domiciliario o no.
Good day, sir.
Judge, with
Buen
respect
día.
to count one, the false imprisonment,
Oh, I'm sorry, I said the bond. Yes, pardon me, I said the wrong bond. Count one, false imprisonment is $2,500. Count two, aggravated battery on a person 65 or older is no bond.
En el primer cargo, privación ilegal de libertad, 2.500, y en el segundo cargo, agresión física contra una persona de tercera edad de 65 años o más, pues se impone prisión preventiva.
All right. Now, do you have Yolandra's Q, page 13? I'm doing the correction cases first, then I'll call the private lawyers in the mother's case. Corrections, I'm gonna need Hector, a K, as well as Leon Cobb when I finish your quick cases. Huh? There's no Leon Cobb here? Oh, we're gonna look and see, Mr. Hanfield.
Where?
Ashley says yes. Hi, Mr. Cuties. Do you speak English?
Yes.
Sir, good morning. You were arrested for grand theft, a second-degree felony. It's from looks like it's from August 4th, about a stolen van. I will appoint the public defender's office for you. There's no value for the van. Do you want to reset it, or it's an added charge? State,
It is an added charge.
it is. I'll set a bond, $5,000. Have a good day. Probable cause though for grand theft F3. You found it. Then on page 15, Christopher Privet. Hi, Mr. Privet. So you were arrested for battery by a detainee on another detainee. I will appoint the public defender's office for you. There's probable cause for the charge. Your bond is $2,500. State, you have the victim's name? For Ms. Corey?
This is Christopher Privet.
Yes.
Apologies, one moment. Erlin Roman, ER.
All right, next we have Isaiah Gispert. This added charge. Good morning, sir. You were arrested for a case from October 21st of 2024. The charge is armed robbery with a firearm or deadly weapon. I will appoint the public defender's office for you.
Invoking Mr. Gisbert's right to counsel and his right to remain silent.
All right, this is an armed robbery that involved a shootout. And the victim was struck 3 times on his chest and his abdomen and in his legs. There were cameras, I guess. Both, there's probable cause for the charge of armed robbery with a firearm. Maybe have an additional charges too. You are ordered to stay away from the alleged victims, George Montero and Miguel Brieva. No contact with these alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victims, their home and school and place of employment at all times. Stay away from 9600 South Dixie Highway in Miami, Florida, where this occurred. So I'm granting the state's motion for pretrial detention pending final hearing and holding you with no bond. You will see a judge tomorrow, and that judge will set a final hearing on the state's motion for pretrial detention. Have a good day, sir. We have corrections. You have Leon Cobbs. Not yet. And then I want to bring in Mr. Page 5, Hector K. Or I'll say. Good morning, sir. 1 second. Let me promote your lawyer.
If you want to make me a co-host, I can help.
Yeah, thank you. I'll be glad to do that.
Judge, who is this before the court?
This is Leon Cobbs for private attorney, Mr. Hanfield.
Page 7.
Thank you, Ms. Corey.
Good morning, Judge Larry Hanfield on behalf of Mr. Leon Cobb.
Good morning. Are you able to put your video on, sir? You have to accept a
One
promotion
second.
as a panelist.
Just
It's not working. Do you have any argument at all you want to, regarding probable cause?
Judge, on the issue, if you I was not able to get the A form, if you can read it, please.
I can't read it. It's not PG rated.
Oh,
It's X rated. Or R rated. I
right.
don't know however you want to describe it. Do you want me to reset it in the afternoon, say, or pass it? Maybe somebody will send you a copy of it, but I can't.
Okay, can you pass it, please?
Yep. Ms. Sturgis, can you send Mr. Hanfield a copy? Can you put your email in it in the chat room? Maybe type your email and maybe somebody will send you a copy. Could you have
Will do,
no?
Judge.
Thank you. Hector Ake or Ase. Hello, who are you, ma'am? Oh, his mother's in court. Okay. Are you the victim? No. Good morning, sir. Do you speak English? Yes?
Yes.
All right, sir, you were arrested for strong arm robbery. I will appoint the public defender's office for you.
Okay.
Are you the victim? Are you the victim? Are you the victim? Okay, I know you're his mother. You said it 5 times. Are you the alleged victim in this case? It's a yes or a no. Fine. What is your name? Thank you, ma'am. Please raise your right hand to be sworn. Your right hand. Good morning, ma'am. No, I don't, just listen to the questions. Are you afraid of your son, Hector?
No.
Do you want the court to order him to stay away from you? Does he live with you?
Yes.
But you understand, without a stay away order, the court cannot protect you against any possible future violence.
Said he just took my keys and I was inside the store to buy something. When I came out, I didn't know where he was.
You don't hear the whole thing.
Can't
Steve, do
hear
you have
what
any
you're saying, Judge.
questions?
We
What?
cannot hear what she is saying.
I don't know. She's telling me the whole story and I don't really want to hear the whole story. It's not relevant. She says she's not afraid of her son and she doesn't. Try that microphone.
Oh.
So ma'am, the lawyer can't hear you. Tell us your name again.
Narissa Demoya?
Are you afraid of your son Hector?
No,
Do you want the court to order him to stay away from you?
no.
State, any questions?
No, Your
Defense,
Honor.
any questions?
No, Judge.
Do you lived with him?
Yes.
Okay. So, sir, I'm going to allow you to have contact with your mother, whose initials are ND. You are prohibited from being physically threatening or violent towards the victim. So only friendly, nonviolent contact is permitted. Do you understand, sir?
Yes.
Also, do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the modified stay away order, sir?
Yes.
Thank you.
Your Honor, could I say something?
Of course, ma'am.
Oh, could they release him with R? Is it ROR?
Yeah, I can't do that. Maybe a program, but I can't do ROR.
Would you consider pretrial then, Judge?
Yeah, sure. All right, pretrial services, alternate bonds, 1 minute. So isn't it robbery by sudden snatching? It says he snatched the phone from her hands.
No, he just,
Shh. State.
I'm looking, Judge. It appears that is the case.
All right. Count 1, there's probable cause for robbery by sudden snatching. So it's pretrial services, alternate bond, $1,500. Have a nice day. So he can be released at pretrial. If you have a seat, she'll get your information from you, okay? Where would you like her to sit, outside or in the back? You can sit in the back. Huh? Thank you. Um, All right, moving right along now to page 1. I passed 2 cases also. Excuse me.
Yeah,
let me
no, we
get
can go
this.
back to Miss Castro.
Miss Castro? Let's see. Okay, Margarita Castro. Is she here?
Judge, this is Miss Marshall. They brought Miss Marshall in first. She's
Oh,
the
okay.
one on the calendar.
Give me a moment, please, to get the paperwork. Where's Miss, I'm sorry. Who is this? Miss Marshall?
Yes, she's the first one on the calendar.
Thank you. Good
Page
morning,
1.
Miss Marshall. You were arrested for 1 count of attempted felony murder. It's a case that from September 6th. I will appoint the public defender's office for you. I need a moment to review the arrest affidavit for probable cause.
We'll be invoking Miss Marshall's right to counsel, right to remain silent.
All right, so what would the correct charge be state? There's no underlying felony, I don't believe. Is it a attempted second-degree murder?
Judge, I think it could be that, but I also think it, for purposes of the motion I filed, aggravated battery, with great bodily harm and using a deadly weapon, which would be the first degree felony.
Oh, so that would be the underlying felony for attempted felony murder, the aggravated
I
battery.
asked
Thank you.
not to find probable cause for attempted felony murder, Judge. On page 2, Ms. Marshall indicates this was self-defense after the alleged victim punched her in the face.
And you know, she was on house arrest and was rearrested on this case and on a fugitive hold from Monroe County with no bond.
Hold for F-25 14035.
So best, I would ask you to find probable cause for aggravated battery. There's no indication of what the actual injuries were.
Stab wounds to the neck.
That's probable cause for attempted felony murder. Ma'am, you are ordered to stay away from the alleged victim, whose initials are SA. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim's home, school, and place of employment at all times. I am granting the state's motion for pretrial detention pending final hearing and holding you with no bond. You will see your judge tomorrow, and that judge will set a final hearing on the state's motion for pretrial detention. Have a nice day, ma'am. Next case, did you want me to call up Ms. Castro next? Good morning, Ms. Castro. Ma'am, you were arrested
No, wait,
for,
we need Castro.
sorry. Who is this person? It's okay. Who is this lady?
Okay, this is Miss Navarro Molina.
Hello, Ms. Navarro Molina. Ma'am, you were arrested for
Spanish,
battery on a law enforcement officer, resisting an officer with violence, threats or extortion with prejudice, battery. And
Buenos días, usted fue arrestada por agredir a un policía, resistirse a la policía, amenazas, agresión física
also disorderly intoxication.
y también estar en un estado de embriaguez en la vía pública.
Can you afford to hire a private lawyer, ma'am?
¿Tiene los medios o los fondos para pagarse un abogado particular, señora?
No, no.
I will appoint the public defender's office for you.
Entonces le designo el abogado de oficio.
Ma'am, you are ordered to stay away from the alleged victim, Renee Urdaneta.
Señora, se le ordena alejarse de la presunta víctima René Ordeneta.
No contact with that alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties.
Tiene prohibido comunicarse con la persona en cuestión, que sea de manera directa, indirecta, por escrito, por teléfono, por mensaje de texto o a través de terceros.
And stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Igual le queda prohibido acercarse a menos de 500 pies de la víctima en todo momento, que sea, donde viva, donde trabaje, donde estudie.
And also stay away from the restaurant or bar Copper 29 at 206 Miracle Mile in Coral Gables, Florida.
Además, I'm sorry, what is the bar called?
Copper 29.
Además, tiene prohibido acercarse al bar Copper 29, ubicado en el Miracle Mile.
You're not allowed to go to that business, and you must stay away from there.
Señora, tiene prohibido presentarse en ese negocio y debe alejarse de ese sitio.
There's probable cause for count 1, battery on a law enforcement officer, $5,000 bond.
Hay motivo fundado en el primer cargo, 5,000 de fianza, ese cargo de agredir a un policía.
Count 2, resisting an officer with violence, is $2,500.
2,500 en el segundo cargo de resistirse a la policía con violencia.
Count 3, threat is probable cause for threats to law enforcement, a first-degree misdemeanor. It's $500 bond.
Y hay motivo fundado también para el tercer cargo de amenazar a la policía, 500.
Count 4, battery is $1,000. Count 5, disorderly intoxication is $150.
1,000 en el tercer cargo y 100 estar embriagada en la vía pública, $100.
Have a nice day.
Buen día, señora.
All right, let's change it up a little bit. We weren't able to go there last week because they weren't doing anything, but let's go to Louisiana, where it looks like they have a 5-member panel today, which usually means a larger charge, a bigger deal. So let's see what's going on.
Put it in your packets. Are there any corrections? Hearing none, I'd entertain a motion to approve the minutes. Moved by Mr. Tillis, second by Mr. Prater, to approve the minutes as presented. Are there any objections? Hearing none, the minutes are approved. Thank you. Our next agenda item is consideration of applications for clemency or pardon. And our first case on the docket this morning is that of Mr. Richard Coon. And Mr. Coon is housed at Rayburn Correctional Center, so that is our first remote location. So Warden, would you and your staff introduce yourself, please, for the record?
Yes, ma'am. Good morning. Warden Travis Day.
Keith Baker, Deputy Warden.
Kristen Herbert, records. Tracy Saylor, classifications.
All right, thank you. And Mr. Coon, would you introduce yourself? Tell us your name and DOC number, please.
Richard Coon, 40-30-75.
All right, and let me acknowledge that, you have some folks there, I believe, with you today. You have Roy Kuhn, your brother, Donald Kuhn, your uncle, and your son, Richard Kuhn II. And all of those people want to speak, and we'll call on them shortly to do so, sir. We also have here with us in Baton Rouge, representing the victim, Mr. Michael Tebow, and he's going to also be speaking. And then also joining us by Zoom is from the District Attorney's Office. We have Mr. Butch Wilson, and he'll say a few words also. First, Mr. Kuhn, let me read some identifying information into the record, sir. Mr. Kuhn, you're classified as a second felony offender. You were sentenced in Washington Parish in June of 2013 for a manslaughter conviction. You received a 25-year sentence. You don't earn good time, but your parole eligibility date is June 16, 2032. Is that information correct, sir?
Best of my knowledge, yes, ma'am.
All right. So, Mr. Kuhn, your case was assigned to Mr. Tillis, but before I turn it over to him, we want to hear from you and your guest. Tell us, sir, what led you to prison and why do you think we should vote favorably for you today?
I realized I was living a life that wasn't favorable to society. Doing things I shouldn't have done, which I'm terribly sorry for. I get to prison and I seen where I was messing up. I've taken these classes, self-help classes, and realized I needed to straighten my life out. It was in turmoil, and my dad passed away in 14, so I gave my life to God, Jesus Christ, and getting into these classes and seeing what error of my ways and hanging around positive people to keep me focused and on the right path. And I got them grandbabies. I want to get out there and mentor them and other young children and let them know that there's a better way to life than, just make smart decisions. And a lot of things going on. I'd like to try to keep them out of trouble. If I could say one thing to one kid, keep them out of trouble, that would be the way I'd like to go.
Thank you, sir. Warden, is there anything you can add about Mr. Kuhn?
Yes, ma'am. I'm gonna let Warden Bickham speak, but just to say a few words, looking at his record and knowing, Richard and seeing what he does around here, he's pretty much a model inmate and does a lot of things for the institution.
Richard has gone through cancer. Throughout the time he was going through cancer, he wouldn't take a duty status. He kept a regular job. Even now, through all of that, and he's come back with a colostomy bag. He's refused the duty status. He's working as a trustee in maintenance. He's in church like clockwork. You can see him in there doing that. And he's remained, somebody's gone through as much trial as he has here. He's been positive throughout the whole thing. And he's, like Ward Day said, he's been a model inmate the whole time he's been here.
Thank you. We appreciate that information. So, Mr. Kuhn, we'd like to hear from the folks who are there with you, who want to speak on your behalf. And first, I don't know if they have any planned order. If not, we'd like to hear from your son first.
How y'all doing? Thank y'all for the time. My name is Richard Kuhn II. This is my father. We're here for him. I know he has changed. I've seen a change in him over the past couple of years. He's got grandkids. I know he wants to be a part of their life. It's rough coming to visit with him during, weekends and all. It'll be a great thing for him and our family if we can have him outside of these walls. I've spoke with several folks in and out that's been in this facility. Inmates that done been out, and they said, you know, my dad's been a great mentor to them. And all these are peers my age, you know, younger fellas. They told me that my dad's been doing great things, and they're ready to, excuse me, see him get out as well. I'd like, you know, time's limited, and what time he has left to be able to enjoy it with his family and friends and these grandbabies.
Yes, sir. We appreciate hearing from you. All right. Y'all can decide who's next. Just come up and introduce yourself and tell us what you'd like us to know.
Yes, ma'am. My name is Donald Cohn. Thank you for giving me this opportunity to represent my nephew, Richard. I'm retired United States Air Force, and also I'm commander of the American Legion in Bogalusa. And that way, I know a lot of people in Bogalusa that already offered him jobs, some opportunities when he gets, hopefully when he gets out. We got jobs at the American Legion. We're gonna keep him busy, and I've been coming to see him ever since he's been here at least once a month. And his attitude has changed drastically for the better. And he's just better to be around, better to talk to, just a different person. He's always been a good guy, but he messed up. He knows that now, and I know he's remorseful for that. But I think it'd be very productive if he goes back to society, and I think he's gonna make a very good citizen. Thank you very much.
All right, thank you.
Morning. My name's Roy Kuhn. I'm a resident of Lafayette, and myself, I'm a retired Army veteran with over 24 years. And obviously, I know this young man. He's a little older than I am, but I still call him a young man. He made some bad choices in life, and some that I wasn't proud of, and I know he's not proud of. And he's very remorseful from the conversations that we've had, many different conversations. But the most important thing is that he gave his life to Jesus, and to me, that means everything, regardless of the outcome of this hearing. I know where his soul's bound, and that's the most important thing for anybody in this world. But I do know that he'll be a successful member of society, just based off of the things that I've noticed with him and witnessed, you know, sharing the word of Christ with him and the things that he shared with me. I really truly believe that he'll be a good member of society this time. And he'll never go back to the life that he once had, and nobody wants that. And I don't think he ever will either. And I'd like to thank each one of you for taking the time out, for allowing us all to come here and speak on his behalf, because that means a lot. A lot of people don't get that opportunity, and thank the warden and the deputy warden for their time as well.
Yes, sir. Thank you. All right, now, we'll hear from the opposition. Could Mr. Michael Tebow, please?
Yes, hi, I'm Michael Tebow, Joe Tebow's brother. And this incident has caused a lot of pain for both myself and my family, my other brother, my parents. My dad was devastated by this. We all never really got to say goodbye. It's been very difficult, and it was also difficult for the 5 years that we went through this, waiting for an outcome. It's taken its toll on everyone. I tried to help with his children. I actually adopted one of them for a couple of years, and it was a challenge. But I kind of, what I just saw on the screen has really impacted me because I myself have given my life to Christ. And that's one thing I can relate with, and I know that Jesus came here to forgive us. And grace is something that is not earned, it's free. And I don't know, I came here to oppose, but when I saw what I saw in my heart, I say that it seems genuine to me that Jesus has impacted Richard's life. And the pain that I have, and I still have when I hear a song that my brother and I say, it hurts, it does. But I hope that it probably hurt God when he gave his son to for forgiveness. So I kind of am not here to oppose anymore. I'm here to say that I think that maybe Richard deserves a second chance.
Thank you, sir. We have Mr. Butch Wilson from the DA's office on Zoom.
Hello?
Yep, there you are. We hear you.
Can you see me?
No, sir, we can't see you.
Okay, I don't know why this video, let's see. Okay, can you see it now?
Yes, we can.
Okay, I apologize for that. I'm messing with my iPhone. I can appreciate what the gentleman just said, and I'll be very brief. I know you folks have a very difficult job and tough decisions to make on cases like this. I just would point out, I think it needs to be said that this crime, which was a terrible crime, the victim in this case died of a ruptured spleen. He was beaten and kicked to death over allegedly a stolen checkbook. This man could have done what law-abiding citizens do and called the police if he thought that this acquaintance of his, who he then killed, had done something wrong, and he chose not to do that. He chose to act viciously. And this is the fact that sticks with me. This was not a youthful indiscretion. This man, this offender, was, I believe, 46, 47 years old when this awful crime occurred. This wasn't a couple of kids getting drunk and getting into a brawl. He knew what he was doing. And I just don't know. I mean, I can appreciate what the gentleman just said a moment ago, but I know for myself and on behalf of the district attorney's office and on behalf of law enforcement, we cannot trust someone who acts out like this well into their adult years, not acting out in this fashion. That's about all I have to say about this.
Yes, sir. We appreciate hearing from the DA's office.
Thank you.
Mr. Kuhn, as I said, your case was assigned to Mr. Tillis, so would you answer any questions he has?
Good morning, Mr. Kuhn. How are you?
Pretty good.
What are some of the classes that you've been taking since you've been incarcerated?
Pre-release, preparation, living in balance, celebrate recovery, AANA, a vow, SERP, and I have quite a few.
Which one impact you the most or influence you the most?
I would say celebrate recovery.
I read through your case and you were drinking at the time on drugs.
Sir?
When I went through your case, I saw when this happened, you were drinking, you were on drugs.
Yes, sir. I would drink a beer, a couple of beers.
A couple of beers.
Yes.
Okay. I have no more questions.
What is the doctor's prognosis for Mr. Coon? What is his current condition?
He's stable. He has his colostomy, but he has follow-up medical appointments that he'll be going to periodically, and he's followed here by the doctor and nurse practitioner in the chronic clinics.
Okay, thank you.
So, Mr. Coon, how old are you?
64,
And how much time have you done?
14 and a half.
And I misspoke earlier. I said you're not eligible for good time, but you do have a good time date, which is in March of 2035. Your parole eligibility date is in June of 2032. Generally, when we see somebody come before the pardon board, we would give them relief through parole eligibility. You already have that. What is it that you're seeking today? Specific.
I would pray that y'all could commute my sentence to knock off some years for me.
And so I have one more question. In all the classes, and you have taken quite a bit, did you take victim awareness?
Yes, ma'am.
And how did that affect you? What did you learn in that class?
It reminded me a lot of my failures, where I was wrong and things I was doing wrong. I became aware of it, and try to correct it. And like I say, I stay around positive people and they help me focus on what I need to do to correct that problem. They can keep me held accountable.
How many victims do you have?
Just that one in this particular case.
I don't have any other questions. Ms. Stapleton?
Yeah, I do. When you were asked how many victims do you have in the victims awareness class, they teach you that you have multiple victims. You just heard from the brother, he's your victim also.
I'm sorry.
Children, and I guess that's coming to mind now. So I don't understand. I really don't. When people are way too old to be doing this and they're in their 20s, they said they were foolish and young, and they really weren't. But you were in your 40s, and the rage that you got over that checkbook, and yes, you dragged the man out of the truck, you were kicking him, you were brutal to him. And he died from the complications of a ruptured spleen, but he had rib fractures. His head showed layers of contusions. And I heard his brother and talk about mercy and grace, and that's true. But actually, you got mercy and grace when you got sentenced to 25 years or something like that. That's my take on it. I don't have any questions.
All right, I don't see any other questions. I think we're prepared to vote.
Yes.
Tell us.
Mr. Coon, due to strong law enforcement opposition and the length of time you've served, my vote's going to be to deny.
Mrs. Stapleton?
Concur with Mr. Tillis for the same reasons.
Mr. Prater?
I'm willing to give you a shot, but you can't get it with the votes now. And so I applaud you for what you've done. I especially applaud the gentleman that spoke here about his faith, and he lives it. He doesn't just talk it. So I applaud him for what he said. My vote would be to give you a shot at it. That's it.
Mr. Freeman?
My vote is to commute the sentence to 20 years with immediate parole eligibility. You've done a great job in prison. And Mr. Tebow, I also applaud you for coming here and speaking with us. Your speaking to us really made the difference in my vote.
All right, Mr. Coon, based on what both of the wardens there had to say and what Mr. Tebow here with us had to say my vote today also would be to commute your sentence to 20 years with immediate parole eligibility. However, it takes 4 like votes, sir, to get a favorable outcome, and you didn't get that today. So that the result of today's proceeding is that your application has been denied, sir. Good luck to you, sir.
Thank you.
Gordon, thank you for accommodating us. We're going to sign off 9:31.
Denied.
Yeah.
Yeah. I'm not sure how I feel about that one. I mean, the fact that he was so close leads me to believe that I don't know what it leads me to believe. Again, as the man of faith here, it bothers me when people try to put on the Jesus cloak. But then in the same respect, the fact that the one who is in opposition stood up and said, you know what, maybe we should give this guy a chance. I don't know. I'm very conflicted on it. But it doesn't matter because he's not going anywhere. So it kind of is what it is, huh? Barbara, plug your ears. Well, yeah, let's go to Judge Stevens.
Believe it needs to be higher than what it is. What is it, right? It's, I believe, 500. It's 500. Are you Christopher Harris? Okay. Who's posting your bonds? Who posted your bond? You had a bond when you were arrested for $250,000. Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something? My mom was size. It's 5, so she posted 50,000. Okay. There's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000. Okay, that doesn't bother you at all? That's, I can see you don't seem real upset about it. It would be for me.
The $250,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is.
That hasn't been
still
revoked yet. That hasn't been revoked.
correct.
Okay. In 25 CR 1020, Christopher Harris is present with his attorney. Oh, let's see that. Mr. Adams and the state's attorney. I'm looking at this indictment, which alleges that on or about July 19th of this year, you committed aggravated assault there. And there was a bond set of, it looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right? That's correct. Okay. And just. August 25th. Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion to increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the
Yeah.
50?
The new one, the 500,000.
The 500 was set by Judge Jerome.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont Police responded to East X Freeway in reference to a victim of a shooting. And the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled, and so a $250,000 bond is set in that case. So, just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th of 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, who stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont, with the lights on and the engine running. And observed someone named Arthur Gouldsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got them. You have 3 people at gunpoint and then steal everything, tell them to run and then shoot us. Yeah, Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And we'll put him right at the location at the time of the robbery. And so if that's not enough, an Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry who was stolen from the robbery. Okay, there is a motion to increase the bond. Anybody else want to be heard? I've read it, the 4 corners.
Nothing from the state, Your Honor. I believe it's.
the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all. And the $500,000 bond is the one that you just said was set by the ruling. I believe the state said that he did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the 500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled, and that's something that he has not made, and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything statements?
Your Honor, we're just asking for the other one is at 500,000. We would just ask for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, and then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into our
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness remain in Jefferson County and 2 testifies.
Okay. So just a few weeks later. I'm sorry. This was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, and posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring him did not deter him from committing a more violent crime. So he is in custody and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need, and for the protection of the people, and to see that the Constitution works, so that we can live in peace. The defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost unfortunately to his mother who posted that bond, but that's the way the rules are. Ironically, you don't seem seem too upset, but there are victims in two different situations, but there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial. Okay, all right. That is all. Nishan Herring.
That's a thing, we said it.
Okay. Nishan Herring. Thank you. Okay.
Well, they bring up the next contestant speculation with Bailey in the chat that she wagered her home, the mother. No doubt. And if she did, it's gone now. So that dude's a real piece of work. I agree. We're talking in the chat about possibly one of the dumbest ones we've seen yet. I have no doubt that he is. All right, looks like the next contestant's here.
Raise your right hand. Swear or affirm and that's what the true stuff you have. Okay. Need you to help your finger right. Speak up your right thumb print, right thumb. No, your right thumb. There you go. Yeah. Okay, place it flat right there. That's okay. One more time. On one. Okay. See, I'm gonna adjust you.
25 CR 575 is now called, is it Nishan?
Yes, sir.
Nishane?
Yes, sir.
Okay,
Yes, sir.
Christoph Herring, present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? We proceed in summary.
Yes, sir.
In summary, this indictment alleges that on or about November 4th, 2024 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. It further goes on to allege that you have two or more prior DWI convictions, one in 2016, the other in 2019. Paragraphs 1 and 2 constitute a third-degree felony of operating a motor vehicle in a public place while intoxicated. Paragraph 3 states you have a prior conviction in 2019, July 8th, for illegal possession of controlled substance in the 252nd District Court. After that became final, is alleged you committed the felony of illegal possession of a controlled substance, a second-degree felony. You were finally convicted of that in that 252nd court in 2023 before you committed this offense of the DWI. So this indictment, you were looking at a third-degree felony, actually enhanced to a second-degree punishment because of the prior conviction. So you're looking at up to 20 years in prison. You understand? For the second case, I don't want to dismiss that one. The second case is 25 CF 576. They were third degree felony because they actually with the other two prior convictions, which are similar to what I talked to you about earlier in 2019 and 2023. this third degree felony, you're looking at a minimum of 25 years up to life imprisonment if get your attack. Okay. That's gonna be dismissed? Yes, some more.
Yes, Your Honor, it was a.
Okay. Third degree felony means you're facing no less than 2, no more than 10 years confinement in prison and a fine up to $10,000 to be assessed.
Yes. Sure.
Okay, with all of that, we're putting them on probation. That's the condition. One, why would we do that? He's looking at 25,000.
The facts of the case, Your Honor, no one followed him to the hospital. No one told him. I don't believe he was under arrest at that time. They let him leave with the EMS. They get to, none of the officers followed him there. So when he gets to the hospital, he ends up, I think, leaving at that point without any of the officers even being there.
Oh,
we have no video.
All about?
Yeah.
Okay, I understand that. Okay, that's weird.
I think probably with those priors, he's got a drug alcohol issue. I think it would probably best be served to deal with that and be forced to. There were controlled substance issues.
He crashed his vehicle too. Right?
That's correct.
And he's not eligible for probation in a trial. Right?
That's correct.
That's just to see where he's at on review and discovery, Judge.
Shannon Ardwan, please. Let me see all those cases. Okay. Y'all are going on the murder first, I guess?
Yes.
Mhm. Shannon Ardwan, please. In 22-40911, there's several different cases, but the state is electing to move forward on this murder case. When did we set this for trial?
And it has a setting for September 22nd, Judge.
All right. Today, what do we need to do?
Yeah.
Okay, on this case. So, because of the three priors, if those are proven true, habitual offender?
Yes, sir.
You're going to continue to represent yourself, right?
So,
Okay.
also, I have.
What do you need?
I have before the court, motion for, challenge the veracity of the probable cause affidavit.
Say that again?
Challenging the veracity of the probable cause affidavit. I have a motion for the court.
Okay, go ahead.
I was hoping to get that heard.
Go ahead. What do you want to say about it? No, what's your, summarize it. Summarize your point that you want to make. Yeah.
Well, I was contending that after Christopher Raymond in support of arrest warrant made deliberate misrepresentation of facts and omitted material exculpatory information, intentionally knowing and written records disregard for the truth of the affidavit.
All right.
Specifically,
go ahead.
Specifically, he omitted the radio description of the radio suspect's description that was put out by Huntington PD.
Okay.
He omitted it from the probable cause affidavit.
Okay. Anything else? All right. Any response from the state?
My first response is I was not provided a copy of the motion that he's referencing. So if you'll give me a moment, I'll look to see if he filed it with the court.
Okay. The omission of information in a probable cause affidavit does not alone make it a bad affidavit. It's what we look at is what's in the four corners, and if that is probably enough, if it shows that a crime was probably committed and a particular person probably committed it, that satisfies the test. It's the beyond a reasonable doubt standard at trial. That's the big test.
Yeah, that's for later on. So are we saying
It's denied.
You're denying it? So okay. So record is denied.
Yeah. Yeah.
Thank you.
Anything else that you have? Any other motions you wanted to put
Yeah,
out?
actually,
Go ahead.
but my discovery, I haven't been able to praise discovery. It was the former prosecutor, Sonny Eckert, it was dependent on me coming down here, but he's no longer here, so I have not been able to see the discovery.
Okay. Did you get anything at all from him?
Yeah.
They've had 6 different meetings where he's been allowed. I know that, Judge, and that's not an accurate statement.
Yeah, he didn't provide you anything, sir?
Well, he recently, somebody provided my investigator with the media files last Friday.
That's an accurate statement. I did respond to the investigator that's working with him and complied with what they asked for. Before that, Mr. Laird has been present when Mr. Eckhart has met with this man and shown him discovery. So when he
that didn't happen, are you saying they're not truthful about that?
No, I came down here like 3 or 4 times to speak with Sonny Eckert about the discovery, and I was sitting in that room over there for like an hour.
I'm talking about
with the discovery. That's not
go to the meat of the matter. Did he provide you some information of discovery?
Some information, yes, he did.
That's not what you said a little while ago.
Well, he didn't provide me with the full discovery, is what I said.
What are you looking for that's not that you haven't gotten?
The discovery in full is over 10,000 pages. It's over 3 folders. I need to see the discovery.
There's 9 packets that we have redacted that are copies of all the discovery on this. And I don't know that I didn't count the pages, but there's a lot. And what I've been advised is that there's been meetings between Mr. Eckhart and Mr. Ardwan to allow him to review it.
And that's not a meaningful opportunity to assess that information.
The unfortunate situation we're dealing with is that he cannot leave with the items. So we've been doing our best to provide him access to the discovery. So it's a meaningful
How is that going to
date.
work? How does it
difficult,
work for
Judge.
him when he's representing himself?
That's why he's got an investigator. That's also why he's got a second chair.
Okay.
He has a standby counsel. They have access to the discovery as well, Judge.
They may have access, but he can represent himself in his own way he wants. And
then I'm open to whatever suggestion you have as to how to
give
give
him
it to
copies
him.
of everything you have.
Okay.
Okay. But
We have redacted copies upstairs. I can come down and give it to the council.
how long would that take to get done? A few days?
No, Judge, I can take care of it this morning. I just needed to know what he was going to state this morning.
Yeah, I want the discovery in his hands as soon as possible.
Yes, sir.
All of it.
Thank you, sir.
Anything else?
That'll provide him
Here's
the
what I'm
written.
gonna do is I'm gonna review this in a couple of weeks. I don't know how much it is. If it's a lot, it's gonna take a while to read. I wanna know where you are in a couple of weeks. You're probably interested in moving this case as quick as possible when you're ready.
When I'm ready.
September 22nd,
We should.
Well,
special setting.
well, let's have him up on September 22nd to see where he is on moving forward.
And if they'll hold him, I'm going to provide the written access we have, Judge.
And that'll be full discovery?
You're not gonna go.
If you don't get the question, me, I'll respond.
No, you're
I'm asking the judge, I was just looking at you.
No, Tom, look, yeah, don't do that. Look at me, Tom. Yeah, because.
Will that be the full discovery, Your Honor?
Say that again?
Will that be the full discovery, Your Honor?
It's all the written discovery, Judge. We still have a problem trying to deal with the media. I do believe that providing the investigator the requested amounts, that should alleviate that problem. But what I can provide him today is a full copy of the redacted written discovery.
Give what you can today.
Yes, sir.
And then in 2 weeks, within the 2 weeks or on that 2 weeks, whatever is missing, we want that completed so that he has full discovery. So
I'll tell the court that everything that we've got ready that's redacted is a full copy of all written discovery.
And you had that to give to him today.
It's upstairs. I'm going to get it.
Look at it in 2 weeks. If you think, hey, something's missing here, when you come back,
I noticed
write
he
it
keeps
down.
saying just the redacted.
Sir.
I noticed he keeps saying the redacted. I'm asking for the full discovery. The last time what I was, what I didn't get was the full, what I didn't get the last time was the full BPD license plate reader.
The redactions, the court reviews to determine whether the redactions need to be unredacted.
Redaction is just personal information, Judge. It's not, it's what's
Let me
required
look
by
at
law.
it. Okay, let me look, if you can provide to me, I'll look at it in camera and decide whether.
So you want the unredacted and the redacted?
Yeah,
to
he wants
compare?
everything. If it's been redacted, let me look at the redactions to see if it passed the test.
Yes,
But there's certain information that you can't, you're not allowed to get because it's not relevant in the case for preparation of.
Just want the exculpatory evidence. That's it.
We can't talk over each other.
I understand.
That'll slow down the process, Judge, but I'll bring down the both the copies and the originals for the
All
court
right,
review.
I want to review it and
Yes, sir.
determine whether those redactions need to be unredacted for him to review.
Yes, sir.
What else do you have, sir?
That's it for today.
Okay, thank you.
Thank you.
We'll see you in 2 weeks. Yes, sir.
So this boils down to Judge Stevens taking a redaction action. Okay. Let's go to Michigan. Judge Elmore. I think this is like a bond violation or something. Let's find out.
People in the state of Michigan versus Dawn Auger, AUGER. The case number is 25-3626FH. Here in the courtroom, the court recognizes Ms. Dean Stark, an agent from the from the Wexford and Missaukee Community Corrections Program. Joining me is via Zoom from the Missaukee County courtroom. I see Mr. Denhoughton, the Missaukee County prosecutor, and Mr. Champion, the public defender on the case. Mr. Champion, are you all able to see and hear me there in the courtroom? I don't know if he heard me. I didn't hear anything. Mr. Champion, I'm going to ask again. Can you see and hear me? All right. Well.
We can, Your Honor.
Oh, all right. Thank you. I didn't hear anything. All right. Thank you, Ms. Westorp. Also, joining me this morning via Zoom from the Missaukee County Jail is the defendant here, Ms. Dawn Marie Auger. Ms. Auger, are you able to see and hear the court?
Yes, sir.
All right, thank you. Ms. Auger, we're here today for an arraignment on a bench warrant, which is based upon an alleged violation of bond. I need to inform you what is alleged, what your rights are, and the possible consequences. Then we'll see how you wish to respond. It's alleged here that you failed to appear for drug testing on or about August 23rd of this year, and that it was allegedly your third time for failing to appear for drug testing while on bond. And let me just have a moment as I take a quick look here at the documents. That is supported by a program violation signed by the corrections. Allegedly, there was another failure to appear back on August 10th of this year, and a first alleged failure to appear for testing on August 9th. You have the right to challenge these allegations at a contested hearing, as the court is required to permit or to afford due process. At that hearing, the court would entertain information from the community corrections officer, the other information presented by the prosecutor, and you have the right to present evidence, witnesses, or testimony if you chose to do so. The key here is this could be considered a violation of a court order, which could be considered contempt. Contempt is could be a criminal conviction and sentenced by up to 90 days and $7,500 in fines and costs. However, the court chooses not to treat it as contempt and merely a review of pretrial release conditions pursuant to Michigan Court Rule 6.106. You would, of course, have the right to be represented by your attorney at that hearing. If you're found to be in violation of your bond could be continued, modified, or revoked under the court rules. Hey, were you able to hear all that, Ms. Auger?
Yes, sir.
Thank you. Mr. Champion, you may speak for your client.
Your Honor, in regards to the mistest on the 31st, Ms. Auger would admit to that.
Was there another one?
There's 4.
Oh, I thought the last one was on the 23rd. 31st. Okay, hold on. Well,
I did test for CPS the same day that I did miss a test, Your Honor.
There were a total of 4 missed tests, Your Honor.
yeah, okay. So that's what I'm wondering. I have one. I have one from that's signed by Miss Matsky from Community Corrections on August 9th. One from her on August 10th. One from her for August 23rd. And I do not have one for the 31st here. Hold on. Yeah, no, I do not. But, all right, we'll make note that there was on the 31st as well. All right, so Ms. Auger, I'm going to swear you in first, and then I'm going to go back to the comment that you just made a moment ago. Please raise your right hand for me, ma'am. Ma'am, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. All right, now you are going to make a comment here. Let me first ask you a couple questions. Is it true that you failed to appear on August 31st this year for drug testing after being told to do so?
Yes, sir.
So what happened there? Why?
I got into an argument with my husband. We were camping. I don't have a phone. The cops took my phone. He left me out there. He did come back later, but it was too late for me to test. And I did get a hold of CPS, and I did test that same day with CPS.
Child Protective Services?
Yes, sir.
Okay.
So I was
Ms. Stark, do you
at
have-
the courts, but I was tested through a government official, and it was sent in.
Well, Ms. Stark, did you get that information?
Yeah.
All right. So did you order, like, did your office send her a message saying, or at least randomly have her number, sorry, not randomly have her, but was she notified she had a test on the 31st?
They're required to check their numbers every morning, starting at 5:30 to see if their numbers up.
Okay. And so I think, Ms. Auger, what you're telling me is that there was some disagreement between you and your husband, and law enforcement was called, and in conducting that, they took your phone?
No, sir. In the beginning of my, when I got arrested, they took my phone for evidence. So I have not had a phone since then.
Oh, I understand that. All right, thank you. And when was she placed, Ms. Stark, when was, Ms. Auger placed in our probation? Looks like, well, Ms. Augie, so she was, I see the felony information is August 8th. Did she ever come in and do the interviews or information?
She signed up with our office on 8/4.
Okay, all right. So, Miss Auger, what about these other events? Did you miss testing on the 23rd of August?
When I first started my testing, I was confused on, it was a weekend. And it was too late for me to test, and I went to jail for those. But since then I learned, you know, to be aware of the weekend. And both times the one I tested for CPS, and then the last one that I missed, I did attempt to get a hold of her again. She never got back to me.
All right, so Ms. Stark, has she ever tested?
She has tested 4 out of the 8 times she tested.
Okay. Tell me what dates, beginning with the first, that she did show up and test.
She showed up on 8/13, 8/18, 8/27, and 8/28.
Okay. But did she fail to appear on 8/9, 8/10, and 8/23 as well?
Yes, and 8/20 and 8/31.
Okay. Mr. Champion, do you have any questions for your client or Ms. Stark?
I do not, Your Honor.
How about you, Mr. Denham?
No, I think Ms. Stark has indicated the dates that we're missing, Your Honor.
Thank you. Ms. Stark, on your information that a customer signs, tell them that they can go take tests through Child Protective Services or some other agency without notifying you?
No, it doesn't say that. However, we would take that, but she didn't contact us.
Okay, now she says that she called and left a message, but do you all have a message from her?
We log all messages.
Yeah. Yeah, when you say you log them, you check them the next day and actually record them in a book.
They're kept on in a book as well as putting up every file.
All right. I'm gonna make sure I go back and ensure some due process here. Mr. Denhout, did you have any further questions?
No, Your Honor.
And again, Mr. Champion, how about you, sir?
No, Your Honor.
All right, thank you. Well, we've been, the defendant has pled to one of the counts, and we've heard testimony satisfying the elements as to the 3 other issues. The court finds that the defendant has violated her bond conditions on August 9th, August 10th, August 23rd, and August 31st. Okay, of this year. So now the question is what does the court do with the defendant who in 1 month, she has complied a couple times, but once she takes a test and it's negative, then when she gets another test, which by the way tells me she knows how to, and has the absolute ability to call and check to see if her number is being called, and then she doesn't come in, but maybe goes to another office, which is not the Department of Community Corrections. If you don't make the effort, Ms. Auger, to call their office and have them, the other, somebody go get that report. You telling me that you that you went to another office and you didn't make sure that the report got back to them? I don't know. So the answer is no. Now, but hold on. I'm gonna let you make another request or another comment. Mr. Denham, your position on behalf of the people.
Thank you, I would note in the lower code, so the date of the original incident was 7/12, it was a traffic stop. Defendant did test positive in the district court testing on 7/20 and failed to appear on 7/19. I think that's what Ms. Auger was alluding to, the prior mistest when she initially was on testing. Then there's the 4 tests now. We would respectfully request that the court consider increasing the bond, which is currently set at 5,000 cash surety, and or increase the testing, Your Honor.
Thank you. Were there any other terms or conditions that I gave her? Like, is she doing any EOP program through you?
She is not, Your Honor, but we would request that.
All right, Mr. Champion, anything further?
Your Honor, Ms. Auger has a very limited criminal history. Currently, she's going through a difficult time with her relationships. I would ask the court to reinstate her bond at this time.
Now, I told you you'd have the right to make a comment. Ms. Auger, is there anything else you wish to say?
Yes, like my lawyer said, I am going through a hard time. I do not have a vehicle. I am splitting up with my husband. He's made it very hard. He did re-invoke my bond just out of spite. I really wish somebody would just give me a little, help here. I do understand the seriousness of what is going on. That's all, Your Honor.
All right, what is going on? What is so serious and what's going on?
I'm in big trouble. I understand what I have to do, and I have done my very best to do that. But when I'm put in the woods with no way of getting out or no phone, but then he comes back and I do, in a hurry, try to get a hold of CPS, and thank God she did come out that day and she did test me. I thought that would be approved through the courts because my lawyer said just test anywhere. I didn't have the $100 to test through a facility. But I did try my very best, Your Honor.
Well, did you ask CPS? Hey, you're gonna get this to Miss Stark, aren't you?
Yes, sir, and she did say that she would do that.
Okay. All right. What took you out or forced you out into the woods?
Excuse me?
You said you were forced out into the woods or something like that? What do you mean by that?
I wasn't forced out into the woods. We went camping and then had a disagreement, and he just took off and left me there in my camper.
You said he revoked your bond? What do you mean by that?
He took his name off of my bond because I wasn't listening to what he had to say. He wanted me to do this. And we were fighting at the time, so I didn't listen to him. So he said I was a flight risk. I am not a flight risk. I turned myself in when I found out I had a warrant. When the bounty hunters came, I didn't run. I politely opened up the door, told them I was right here. Didn't give them a hard time. I wasn't out partying. He's broke out my windshield. He's done some things, broke my items.
All right. Well.
Your Honor, so the court's aware there was 2 bonds in this particular case, one posted by a surety company, and they have revoked those bonds.
So does she have a bond right now at all?
She's not posted a bond. So no, she does not have a bond.
Oh.
You have the paperwork, Judge, to sign to cancel the surety in your office.
Oh, I see. All right. Well. Well, is everyone else here thinking ahead? If I have a piece of paper requesting after she's in jail and the bond agent has asked me to revoke it.
Judge, this is the one that Judge Ransom texted us on Saturday.
Yeah,
Remember?
yeah, I recall. And here's
Okay.
Judge Ransom, did she sign it revoking it?
No. She
All right,
just
well
gave
then-
us a heads up that the surety was wanting it pulled.
So, all right. Do I hear anything else from the parties in Missaukee County?
What we would ask, since the bond is being revoked or the request has been made, that the defendant be remanded at this time.
Well, that's not the right, and I appreciate that, but not everybody's getting this, but I will go ahead and tell you what's gonna happen. It's a bit silly. Because I can't grant her bond. She doesn't have a bond. If the bonding agency has asked me to revoke it, they have the right to do so. And I have to sign it. So, find that the defendant has violated the conditions of her bond. That part's easy. And I need to take just a brief break right now. One moment. Everybody recess in place. I'll be right back.
Okay, well, we wait for him to come back. Oh, never mind. He's coming back right now. That was fast. Okay.
Because the court has received a notice of the cancellation of bond, which is a right to be requested by the surety or the bondsman, the court has signed it, therefore the bond is canceled. The court will continue the bond as previously set by this court and add to it a term or condition that she is to enroll in an enhanced outpatient treatment program through community corrections. Now, even though I have continued bond, that doesn't mean she gets out today because she doesn't have a bond posted. She can go out and post one. That's why I was asking the counsel there in the courtroom, does anyone have any other requests? So, Miss Westorp, why don't you go ahead and tell me what her bond was?
She had two bonds, Your Honor. One was a $25,000 and one was a $5,000. They were both surety, cash surety.
Is there one case or two cases?
Both for this case.
Why were there two bonds? I'm confused.
Because she had a bond violation at the district court. And so they added an additional $5,000 that she had to post because of her bond violation. So she had two bonds.
Oh.
So it's a total of 30.
Okay. All right. Anything else, counsel?
No, Your Honor.
All right, that's the ruling of the court. I'm not terminating, I have canceled her bond, but she can still go out and post or repost her bond. Thank you. We're adjourned.
Thank you, Your Honor.
Probably about as good of an outcome as there's going to be there. However, the 10% or whatever she posted with the original bondsman is gone now, so she's gonna have to come up with that again with some other bondsman, I suppose. Let's let's go back to Louisiana. I believe this is going to be a pardon hearing this time, which explains the 5-member panel because it's normally a 5-member if it's a pardon hearing. But there's a dude in a suit, so that implies pardon. Let's see what it's all about.
Good morning.
Good morning. And we have with us Maria Giano, who will serve as interpreter for Mr. Valdez or Castro. How should I address him?
Mr. Castro is what he goes by in the United States. In his country, it's Castro Valdez.
Thank you, sir. And would you introduce yourself? I see we have two attorneys this morning.
My name is Martin McGarrestein. I'm an attorney in Florida. I represent Mr. Castro in certain immigration issues. And I've assisted him in this pardon process.
Okay, and we have Mr. Ernest Bauer, is it?
Yes, ma'am. My name is Ernest Bauer, and I am a attorney in Covington, Louisiana, St. Tammany Parish.
And who will be presenting on behalf of Mr. Castro this morning? Both of you?
I will be taking care of most of it.
Okay.
Martin McGarrestein.
Okay. Ms. Maria, would you introduce yourself for the record, ma'am? You're muted still.
Good morning. My name is Maria Angelica Gann. I'm a Spanish interpreter.
All right. And so we want to ask Mr. Castro to introduce himself for the record.
Señor Castro, ¿se puede decir su nombre completo, por favor?
Roberto Castro.
And so let me just read some identifying information into the record. Mr. Castro is classified as a first felony offender, and he is seeking a pardon with restoration of firearms. He was sentenced April 2008 for manufacture and growth of marijuana. He received a 5-year suspended sentence and was placed on active probation.
Señor Castro, usted está clasificado como ofensor de delito de primer grado. Está solicitando una audiencia solicitando indulto y libertad condicional. El registro dice que usted el abril del 2008 los cargos lo sentenciaron por 5 años por manufacturación de marihuana y está solicitando también restauración.
Is that information correct?
¿Es correcto eso?
Sí.
Yes.
Okay, thank you. So, and Mr. Martin, at this point, usually we'll ask the applicant to tell us how did they wind up being sentenced and why should we vote favorably today? Would you like him to do that, or do you want to do that on his behalf?
I could proffer up to a certain point because I'm very well versed in it, in the situation.
Okay. Well, go ahead and tell us.
Okay. He came to the United States and lived about a year in the United States prior to going up to Louisiana. Very common when you arrive from Cuba, you have family members that help you to start your life. And just by ways of a correction on one of the documents, he was lawfully in the country under a parole that was granted to him, as well as work permit. He was not a lawful permanent resident. That's a correction that needs to be addressed. So while he is in the country for about a year, it's time for him to move off on his own. And at that point, he has friends in Louisiana, one that invited him up to Louisiana, gave him an efficiency next to a house that was growing marijuana and was going to pay him $500 a week to stay in the efficiency, so it would appear that somebody was living in the house and basically be, for lack of a better way to say it, a guard while the owner of the property was out of town. He agreed. He went up. He knew there was marijuana in the property and moved into the efficiency and was there a very short time before the police came, located the grow house, arrested him as participant in the grow house. It is my understanding that the brother of the owner was also arrested, but the owner himself was not. At that point, he was taken to court, was not a very long process, pled guilty for his participation, knows what he did, knows that he did wrong, has never come in contact with the system since, was given 5 years of probation. And after 3.5 years, it was early terminated. The probation was immediately transferred to Florida, where he served out the probationary period of 3.5 years when it was terminated. And then I believe the court issues a first offender pardon, which is what happens after that. Now, when he came back to Florida, he lived with an aunt and started to do everything correctly, which he should have done from the minute he stepped foot in this country, but he didn't. He knows it. And has started to live a very proper, law-abiding life. Lucky for him, he met a young lady about 12 years ago. Her name is Yanladies Rodriguez. She's a U.S. Citizen. They've been together for 12 years, and they consider themselves husband and wife, although it would not be a paper husband and wife. It would be more along the lines of common law, which is recognized and is not recognized in some places. But he has been working ever since, and now they have two lovely young children, born 2021, I believe, and 2023, I believe. So they're young, and he knows he needs to teach them what not to do in life and what to do in life. He has grown. All he does is work, him and his wife. His wife owns businesses that he works in. He's done car wash. He's done landscaping. Originally, at some point, he was doing electrical work as an assistant. He does whatever work he can to earn a proper living and assist with the taking care of all the family bills and the things in life that need to be taken care of. And at that point,
stop just now and let's let Miss Maria do
She'll
that for us.
translate.
That point, yes, thank you.
So Gao está explicando que básicamente la historia de lo que sucedió cuando tuvo los cargos, que usted cuando llegó a Estados Unidos tenía amistades familiares en Luisiana y que lo solicitaron primero, lo dejaron quedarse en esta hacienda, básicamente como guardián de la casa de al lado donde estaban creciendo marihuana, y que eventualmente arrestaron a las personas involucradas y lo arrestaron a usted. Y que usted reconoció su participación en esto y tenía conocimiento del crecimiento, y en ese momento le dieron probatoria por 5 años, y eso luego terminó y se transfirió a Florida, donde usted logró hacer la probatoria de acuerdo a todas las condiciones por 3.5 años. Y que usted sabe lo que hizo fue incorrecto, su participación en este caso, y que desde entonces conoció su actual pareja, Yenedelis Rodríguez, que es una ciudadana de Estados Unidos, y que llevan 2 años juntos, aunque no estén casados, tienen una relación y tienen 2 niños que me pareció, él dijo que nacieron el 21 y el 23, y que ahora su pareja tiene negocio, usted trabajando, ha hecho lavandería de auto, trabajo eléctrico, y que están tratando de hacer lo que debería hacer, lo que debería haber hecho cuando llegó al país, que es vivir de acuerdo a las leyes correctamente, y que están tratando de enseñar a los niños la forma de vivir correcta.
Thank you. So I think let me just turn it over to Mrs. Stapleton. If Mr. Castro's case was assigned to her, she may have some questions.
Okay, well, the attorney, you did answer a question because I didn't count parole. He was a legal citizen in this country so quick. So yeah, on parole because he came over here on the boat. Is that correct?
That's correct. And upon arrival, Cubans were at that point naturally given parole entry into the country under the issues between the government of the United States and Cuba that have existed since 1959.
I'll translate that quickly. Dice que está preguntando con respecto a la ciudadanía o la residencia que tenía, que su abogado mencionó que había una corrección que había que hacer en la documentación, que usted no es un residente permanente, pero que sí llegó a Estados Unidos desde Cuba, teniendo la autorización para trabajar y teniendo la libertad en el fondo condicional correctamente, como es el acuerdo con Cuba desde hace años atrás.
Okay, and so also he admitted that he knew he was illegally assisting in growing marijuana.
Y que usted mencionó que tenía conocimiento que estaba ilegalmente asistiendo en el crecimiento de marihuana.
Secondly, electricity was stolen. They bypassed a meter and had electrical work while he was in Cuba. Was he the one that bypassed the meter and stole the electricity?
Dice,
Let her translate.
Was that? I'll let her translate.
Dice que la segunda cosa que mencionan es que además hubo hurto de electricidad y que habían pasado por el metro de medición de esto. Entonces está preguntando si usted estaba en Cuba o si usted fue el que hizo esto, que robando la electricidad.
Responde.
No, yo no fui que hice eso. Eso lo tenía
No,
hecho ya. El dueño de la
no,
casa, todo eso estaba hecho.
I did not do that. When I arrived to the place, that was all done.
Okay. You said that he works for a car wash and landscape, but he has no work permit. How does he get paid?
Dice que usted que trabajaba en la mantención de jardines y lavandería de autos, pero ¿cómo le pagaban si no tenían un trabajo de visa?
He's paid as a contractor with a 1099.
Que lo pagaban como constructor independiente con el formulario 1099.
Would he turn in an income tax form?
Yes, he does.
Está preguntando si usted entrega los formularios de impuestos y la respuesta fue sí.
Sí.
Yes.
Well, I'm curious because he said he can't get a worker's permit.
Está curiosa porque indicaron que no podía obtener un trabajo de visa, una visa de trabajo.
He cannot. It's an issue. It's an absolute issue. And the best he can do at this point is accept his payment as an independent contractor, and as needed, file his income tax returns and pay his taxes.
Es correcto, no ha logrado sacar visa de trabajo y es un problema. Y lo mejor que puede hacer ahora es aceptar la forma de pago como independiente, como contractor independiente con el 1099 y cuando es necesario tramitar los impuestos.
I don't have any further questions.
Any other question? I don't see any other questions. Anything, Mr. Martin, is there anything you'd like to add before we proceed?
Well, first of all, and I probably should have done this before, present in the room, and neither one was going to testify, would be his wife, Ladies Rodriguez, and his uncle, Pedro Romero. Neither one was going to testify, so I hope I didn't do anything improper. This is my first time before your board. Anything
I'm going to translate that. Sorry. Está preguntando si hay alguna otra pregunta, si hay algo más que quieran agregar. Dijo que no, que lo único que quería mencionar que lo debió haber hecho antes es que tenían presente en la misma sala su pareja, Elisa, y su tío Pedro, que no iban a dar testimonio y espera que esté ok, que estén ahí en la sala.
I'll just add based upon two issues. One is the concern, which is a very valid concern about his employment. He has family obligations. He's in the country. He came in the country. He was granted a parole upon entry into the country. He had a work permit. At this point, they do not renew work permits under this situation. So he has been doing what is the best he can for his responsibilities with his family, and paying his taxes, which are the goal of being in the United States. You work, you pay your taxes. And that is the best way possible because he cannot be an employee of anybody because he does not have an employment authorization. And secondly, the pardon that we're
Sorry,
requesting.
could you please allow me to translate the first issue?
Absolutely, I'm sorry.
Thank you. Thank you, sorry. Que hay dos asuntos que quiere mencionar. Uno es la preocupación sobre la situación de trabajo, que es válida, pero que la respuesta a esto es básicamente las obligaciones familiares, que usted llegó al país bajo libertad condicional, correctamente, obtuvo un permiso de trabajo en ese momento y que ahora bajo las circunstancias y la situación no fue capaz de renovar eso y que ha estado haciendo lo mejor que puede con respecto a su familia y sus responsabilidades, paga impuestos, que es el gol en el fondo de estar en este país, de trabajar y pagar impuestos y proveer para la familia, y que en el fondo está haciendo lo mejor que puede dentro de las circunstancias sin poder ser empleado de ninguna otra compañía.
And secondly, we're seeking a full pardon because that would be what we would need to give him a clean start in life. Not that he deserves one, but it's one that we are requesting because if you look at the big picture, he came to the country, he was directed wrong by friends, he knew what he was doing was wrong. Now he realized it's a huge deal. It's not a big deal. It's a very huge deal what he did. It's narcotics. And 17 years have passed since the incident, and he has not come into contact with law enforcement in those 17 years, which is rather a common life for everybody in this country, with minor exceptions. The people come into contact with law enforcement all the time, but they're doing things wrong. If you're doing things right, chances of you coming into contact with law enforcement is next to nothing. And that would be significant for 17 years. At the time of this incident, he was 19 years old. We as a country have recognized that younger people do not have the mind properly developed at that young age to make proper decisions. Although we're responsible to, sometimes we don't. And if we take that into account, 17 years have passed. He's well into his 30s now, has a wife, 2 children. And well, I'm just hoping that you would see the big picture and grant him the pardon. Thank you.
Sorry, would you like me to translate? Okay. Segundo asunto es que están solicitando este indulto, el perdonarlo, para poder comenzar nuevamente su vida de buena forma. No están diciendo que lo merece, pero están diciendo que básicamente llegó al país, fue dirigido incorrectamente por amistades, sabe lo que hizo estuvo mal, sabes que fue un problema grave, en el fondo que fueron narcóticos, y que esto han pasado 17 años desde el incidente y durante todo ese año no has tenido ningún otro problema con la ley, lo cual es significativo porque la mayoría de las personas, en el fondo, sucede mucho que en 17 años podrían tener algún problema con la ley, no ha pasado nada. Esto además sucedió cuando usted tenía 19 años y que es sabido que en ese momento muchas veces la mente no está completamente desarrollada, y que ahora estás en los 30 y tienes una pareja, una familia con niños, y están solicitando por esas razones solicitar este perdón.
Thank you. Okay, I do have one more question based upon his answer to question number 7. Okay, he's considered a contractor. He does a 1099, he pays income tax. But part of his answer here says, my employer pays me in cash because he knows that I do not have the official authorization to work, but he likes me. He likes the work I do and he wants to. So does he tell all of the cash money he's received, that's what he turns in?
Wait, we're gonna let her translate that, please.
Thank you. La otra pregunta que tiene es con respecto a la pregunta 7 que usted respondió, que básicamente dice que usted está trabajando como constructor independiente bajo el formulario 1099 y que usted paga impuestos. Pero dice que ahí dice, sale indicado que usted declaró que su empleador le paga en efectivo porque sabe que no tiene la autorización apropiada para trabajar, pero le gusta el trabajo que hace y le gusta como persona, entonces él hace eso y le paga. Entonces la pregunta es si usted realmente declara todas las ganancias en efectivo.
And I had that discussion with him, and yes, all the cash payments were reflected on the 1099, which is what he files his tax returns based upon.
Y sí, tuvo esta discusión con usted, que todo el dinero que usted gana en efectivo está declarado en el formulario en el 1099 que tramita para el impuesto.
All right, there's no further questions, so we are prepared to vote. We will state our vote and our reason for our vote and allow the translator to do the translation before the next vote.
Ya, no tiene más preguntas, va a ir a votación y la razón por la cual toman esa votación y luego van a dar oportunidad para traducirlo.
Mrs. State.
My vote today is to deny because he was here on a visa, which was the grace of the United States.
Mr. Prater? Oh, I'm sorry. Translate, please.
El primer voto es negarlo por el hecho de que estaba aquí inicialmente en el país bajo una visa que se le otorgó con la bondad del país y que esa era la oportunidad que tenía para hacer las cosas correctamente.
No, my vote would be to grant. I think that's something that happened that many years ago. If you're a citizen, we would probably grant it. And so this case, ICE knows that he's here. If they choose to deport him, that's between ICE, and certainly that's what they right that they have. But if he wants to get things straight, and can possibly get things straight, I don't want this to be held over his head when it wouldn't have been held over anybody else's head.
La segunda votación es otorgarle el perdón. Dice que esto pasó hace muchos años y que si fuera ciudadano seguramente le otorgarían el permiso y que inmigración sabe que está aquí y es el derecho que ellos tienen de saber si hacen algo mayor o no con respecto a esto, pero que está tratando de enderezar la vía y que cualquier otra persona debería tener derecho a hacer eso.
Mr. Freeman.
Okay, my vote is gonna be the same. I'm gonna vote to grant 17 years cleansing period, which is a very good cleansing period, nothing else on your record. And as we stated before, ICE does know that you're here and they can take their proper action. But my vote today is to grant out firearms.
Su votación también es de otorgárselo por las mismas razones. Dice que ha tenido un periodo de 17 años de limpieza, como lo llamo, de corregir los errores y que eso no es menor, sin tener ningún otro historial penal, ningún otro problema. Y que lo mismo, dice que inmigración están al tanto y que ellos podrían determinar hacer alguna otra cosa, pero que creen que deberían otorgarle este solicitud.
Mr. Tillis.
My vote is same as Ms. Staples.
I'm sorry, I can't hear. It disconnected for a moment. Could you please repeat?
My vote is to deny, same as Ms. Staples.
Dice que su voto es negárselo, lo mismo que la señorita anterior.
Mr. Castro, my vote today would be to recommend the pardon without restoration of firearms. You were age 19 at the time. It's been 17 years. You have no other contact with law enforcement. And then if you're successful, work with your attorney to resolve your immigration status.
Su voto es otorgarle el perdón sin restauración de arma. Han pasado 17 años, era muy joven. Quiere saber si se le otorga el permiso, cuál es su plan yendo hacia adelante.
But today it requires 4 votes to have a favorable outcome. Mr. Castro only received 3 favorable votes, so the outcome of today's proceeding is his application is denied.
Pero, señor Castro, usted necesita 4 votos en este momento para tener que se lo otorguen, y en este momento usted solamente recibió 3 votos favorables, por lo tanto, el resultado hoy es que la aplicación es negada.
And that concludes our proceeding today.
Y eso concluye los procedimientos judiciales hoy día.
Thank you, board.
Thank you.
Gracias.
Denied. Okie dokie, friends. So that's how that one went down. Let's do this. We went here a couple of weeks ago. This is DeKalb County. This is their bond hearing court. Different judge this time. It's Judge Markeith Wilson. But we enjoyed it the last time we went there. So let's just spend some time. Mrs. TCF has entered the studio. So hi, Mrs. TCF. So you guys watch this, and I'm gonna see what's going on with the missus.
Position 4, Marquise Cobb.
Theo Robinson for Mr. Cobb, and we do have a witness for that as well.
And Allison Lake for the state, and we're ready.
Position 5, Ariana Cyprian.
Attorney Lerner for the Public Defender's Office, and we're ready to proceed.
Anybody for state?
I apologize, Your Honor. Cyprian is Ashley Trent for the state, Your Honor. State's ready.
Position 6, Lavaris Ford.
Theo Robinson for Mr. Ford, Your Honor. We're ready to proceed.
Allison Lake for the state, we're ready.
Position 7, Nathan Gilstrap.
Your Honor, I believe that's going to be private counsel attorney Dennis Scheib.
All right.
And it's going to be Ashley Trent for the state, Your Honor. State is ready whenever that case is ready to be called.
All right, I'll hold for announcement on that one. Position 8, Marquez Kimbrough.
Theo Robinson for Mr. Kimbrough. We're ready to proceed.
Allison Lake for the state, and we're ready.
Position 9, Kevin King.
Attorney Riley Lerner for Mr. King, ready to go forward.
Ashley Wormack for the state. State's ready.
Position 10, Beautiful Lee.
Theo Robinson for Miss Lee. Ready to proceed.
Allison Layton for the state, we're ready.
Position 11, Leon Lewin.
Good morning, Your Honor. Maureen McLeod here for Mr. Lewin, and we're ready to proceed on this bond hearing.
All right.
Ashley Trent for the state, Your Honor. State's ready.
Position 12, Mecca Lynch.
Attorney Lerner for Defendant Lynch, we are ready to proceed.
Allison Layton for the state, and we're ready.
Position 13, Urias Morales Gomez.
Attorney Lerner for Mr. Morales Gomez, and we are ready to proceed.
Ashley Trent for the state, Your Honor. State's ready.
Position 14, Octavius Morel.
Theo Robinson, Mr. Morrow. We're ready to proceed.
And Allison Lake for the state, we're ready.
Position 15, Saifullah Moshfik.
Attorney Lerner from the Law Office of the Public Defender, we're ready to proceed.
Baran Shaw on behalf of the state. State's ready.
Position 16, Jacob Noble.
Your Honor, Teal Robinson for that position. We'd ask for you to hold for our announcement there.
All right.
Ashley Trent for the state. Your Honor, state is ready.
Position 17, Antonius Orso.
Good morning, Judge. Amanda Young for Mr. Orso. And we're ready for the bar hearing.
And state's ready for position 17.
Position 18, Jameer Pearson.
Good morning, Your Honor. Andrea Schlissel on behalf of Jameer Pearson, and we are ready.
Good morning, Ashika Penn for the state. Your Honor, we're ready, and we also have a next of kin that is present on the line and wanted to be heard in terms of bond.
Position 19, Tyler Reed.
Attorney Lerner for Mr. Reed. We are ready to proceed.
Allison Lake for the state. We're ready.
Position 20, Lamorris Russell.
Your Honor, Teal Robinson for that position. My understanding is that we are having to request a continuance and are in the process of getting that filed right now.
Any objection from the state?
No objection from the state, Your Honor.
All right, I'll reset to the next calendar. Position 21, Cedric Smelly.
Yes, Judge. The attorney of record, Ms. Kyle O'Brien, filed a request for a continuance in this case.
No objection, Judge.
All right, that matter will be reset. Position 22, Ahmad Solomon.
Good morning, Andrea Schlissel again on behalf of the defense, and we are ready to proceed.
Allison Lake for the state. We're ready.
Position 23, Ernesto Tenero Perez.
Teal Robinson for that position. We're ready to proceed, Your Honor.
Ashley Trent for the state. Your Honor, state is ready.
Position 24, Xavier Turner.
Good morning, Your Honor. Kanisha Benz on behalf of Mr. Turner. We're ready to go forward. I would just ask, Your Honor, if possible, I need to make an announcement on another Zoom for another county, if I may be excused for about 5 minutes.
Yes, ma'am.
Thank you, Judge.
State's ready, Judge, on that one. Thank you.
All right, thank you. And position 25, Joseph Vina.
Attorney Lerner for Mr. Vina, and we are ready.
Ashley Trent for the state. Your Honor, state is ready.
All right. Attorney Shive show up. Do not see him. All right. Position 11, Leon Lewin.
Your Honor, if I could make a request as well.
Okay.
If we could begin, or if we could call Miss Penn's case just as soon as Your Honor is ready for that. I believe she does have some other engagements whenever Your Honor is ready for that case.
All right. We'll get Miss Penn right after we get this one.
Thank you, Your Honor.
Good morning again, Your Honor.
Good morning.
Yes, I am here for Mr. Lewin.
All right. And I believe that is Attorney Trin.
No, it's Maureen McLeod, Your Honor.
No, you're defense. I got you. I was asking about the state.
Yes, Your Honor. The state
All
will
right.
be representing Mr. or handling that case.
Yes, ma'am. If you can give me a little background, facts, and criminal history.
Yes, Your Honor. Your Honor, he has been in custody for 25 days. He was arrested on August 15th on this case. He is currently in custody without a bond. That was a bond that was set at felony first appearance by Judge Kemp, Your Honor. The incident, as far as the facts of this case, on August 15th of 2025, Your Honor, the victim was driving on the highway with her kids in the vehicle. She was driving away from the defendant. The defendant was in his truck when the defendant tracked the victim down on the highway. The defendant was able to take the kids away from the victim's car, placing them in his truck cab, and then began to drag the victim out of the victim's car towards the truck. The victim was fighting the defendant's efforts to drag her, and so the defendant struck the victim across the face repeatedly in order to get her to comply. When the victim continued to resist the defendant then drug her by the arm and her hair to his truck. The kids who were in the vehicle were able to observe the defendant attacking the victim, and they were crying out, "Stop hitting mommy." The defendant eventually dragged the victim into his truck seat. The victim tried to exit the vehicle, but the defendant tied a truck strap or rope around the handle in a way so that the victim could not exit the vehicle. The defendant then drove the group, which was the victim and the children, to the defendant's father's home, despite the victim expressing that she did not wish to go there. The victim had to cooperate for a while with the defendant so that the defendant would allow the victim to sleep inside the truck. The defendant then eventually agreed to return the victim to her car so that she could drive her and the kids to her mother's home so that the kids could stay at the mother's home instead. The defendant, however, drove the kids in his truck, and the victim followed the victim as the victim drove herself to the mother's home. While the victim was driving her car to the mother's home, the victim was able to call 911 and have officers meet her at the mother's home. Law enforcement officers arrived and they saw the defendant sitting at the apartment steps outside of the mother's residence. When law enforcement officers were speaking to everyone, the defendant did admit to striking the victim multiple times and dragging her to his truck and trapping her inside with a rope, but he said it was because she was having a mental health crisis and was exhibiting signs of self-harm. The victim denied having any signs of mental crisis, and when the officers were speaking to her, she sounded completely clear, composed, and sober, and this was also evidenced by the 911 recording that they were able to listen to, Your Honor. He has no criminal history, Your Honor. We have been able to speak to the victim. She is highly opposed to bond. She is extremely fearful for her safety and for the kids' safety, Your Honor. She is not at her home right now. She's explained to us that the physical abuse over the past year has escalated. She has expressed to us that he is verbally and financially abusive to her. She's expressed to us as well that as of yesterday, she no longer has access to any of her bank accounts, that the defendant is the primary breadwinner, that she gave up her career to stay at home and be a stay-at-home wife, Your Honor. She has also explained to us that the defendant has isolated from the family and the friends, that he has always been abusive to her in front of the children, that he's also from Jamaica, and that she's fearful as well since she does believe that he is a flight risk. She's also explained to us that she's additionally fearful since she does believe that his family has hired a private investigator, and she kind of believes that she might be being followed a little bit. And she's also afraid since she fears that some of her email accounts might have also been hacked. But she is extremely opposed to bond, Your Honor. She's also explained to us that he's a truck driver and that he does travel around the country, or that he drives a lot, and that he does have the resources to flee the jurisdiction. The state's recommendation, Your Honor, is that Your Honor deny bond. We do believe he's a risk to intimidate, that that this is an intimate relationship between these parties, and that there's an extremely vulnerable nature between the victim and her children. The defendant has exhibited all types of abuse, and especially given the facts of this case, Your Honor, and that the victim has explained to us that there's a history of abuse as well, and that these incidents have occurred specifically in front of the children. But the state's recommendation, Your Honor, is that Your Honor deny bond.
Attorney McLeod.
Yes, Your Honor. My client is 31 years old. He has been living in the state of Georgia since high school. He actually went to high school and has 3 years of college, and he has resided in the state of Georgia more than half of his life. Your Honor, these parties are actually married and they share 4 minor children, the youngest of whom is only 10 months old. My client has no kind of criminal history whatsoever. He is a family man. As I said, they share 4 minor children. He tells me that there have been some issues concerning alcohol abuse, and also there is a mental health diagnosis with respect to the alleged victim. He tells me that on the day of this incident, he tells me that alleged victim was highly intoxicated and that the situation, she was driving with the children and it was unsafe. This was a situation where he was just trying to protect the children and also trying to protect the alleged victim, Your Honor. As I said, there's never been any history of any abuse or anything. Both of them are married, as I said. They are in church. I was able to speak with their minister, who has been counseling them for a while as a couple because of some of the issues that they were having in their marriage with relationship to the alcohol and the issues that sometimes come about as a result of the mental health situation. And the minister is on the call as well, Your Honor, and he is prepared to testify to the court. Also, my client's parents are on the call. Given the fact that of what he's charged with, Your Honor, I believe that he's entitled to a bond. He has no criminal history, 31 years old. And if he had been, what they're trying to say is he would have had some kind of record. He does not. He is a truck driver, and the state is correct. He is the primary breadwinner in this family, Your Honor. And therefore, minor children sitting around now with no means of support. My client needs to be out so he can take care of his children. That is his biggest concern. Any kind of bond can be conditioned on no further contact with the alleged victim or no further violent contact with the alleged victim, whatever the court thinks is most appropriate. But we would definitely ask for, if not a signature bond, Your Honor, for a very affordable bond, because keeping this young man locked up away from his children does not serve anyone. I had attempted to speak with the prosecution so I could give the state some background so that they could perhaps investigate a little bit further, because as we all know, Your Honor, sometimes everything a victim says does not reflect the true situation as it has been happening. They've been knowing each other since they were in college together, and they have been married now almost 10 years, I believe, Your Honor. As I said, they share 4 children. I believe that the alleged victim has been having some issues with postpartum depression. That's what I have learned from speaking with not only my client, but with his family and also with the minister for their church, Your Honor. So I'm asking for a bond for him at this time.
Attorney Tran, if I was to grant bond today, what conditions would the state be asking for?
Your Honor, we would be asking for no contact with the victim. We would be asking for ankle monitor, Your Honor, and house arrest with that he resided at a particular location. Of course, with those exceptions to allow him to be allowed to work and go to court and meet with his attorney, as long as he submits his schedule prior, report pretrial services within 48 hours, Judge, no alcohol or drugs, no firearms as well, Your Honor, but those special conditions, Your Honor. And then, of course, I know counsel is asking for a signature bond, but these are bail restricted offenses. I just wanted to make sure the state touches on that matter as well.
This time the court's going to order a bond in the amount of $20,000. He's going to be on ankle monitor or house arrest. He's going to be able to go to work. He's going to need to provide his trucking schedule to pretrial services. He's to report to pretrial services within 48 hours of being released. Then he's also to be able to go to medical appointments, meet with his attorney, the standard conditions. Court. No contact with the victim. No violent contact with the children. And,
thank you, Your Honor.
No firearms or possession of any illegal drugs or non-prescribed drugs. Let me say that.
And I'm so sorry, Your Honor. Did you say alcohol as well?
Yes, ma'am.
Thank you, Your Honor.
All right. Do we have an address form of Attorney McLeod? You can provide an address to Attorney Tran.
I will, Your Honor. I will definitely do that.
All right. Anything else?
Nothing further, Your Honor. Thank you very much.
All right.
A note on her door. She's sitting there by the bed of the courtroom.
All right, Attorney Penn, your case was position 18, Jameer Pearson.
Yes, Judge, that's correct. Is Ms. Schlissel? I can't see.
There, I see her.
Okay. And Miss Carmen Givens. Okay, I see her. Right, Your Honor, this is position 18, Jameer Pearson. Mr. Pearson is 14 years old. The incident date is July 24th, 2025. He was arrested on August 7th, 2025. The incident location is 621, I think it's Walting Way in Stone Mountain. Mr. Pearson is currently in custody with no bond on felony murder charges. The victim is a Deontay Brown, who was 17 at the time of his death. And as stated before, the next of kin, his mother, wanted to make a statement at the conclusion of my summation, I guess. On July 24th, 2025, officers responded to a person shot call at the incident location. Upon their arrival, they found an unknown Black male, later identified as the victim, who had been shot multiple times inside a car. He was located in a red Chrysler 300 that was against a tree at the front of the apartment complex. The victim was unable to speak and was taken to Grady Hospital, where he was later pronounced deceased. Officers spoke with a witness who was also the 911 caller, who stated he observed the shooting. The witness saw the victim sitting in his car when he saw two males, one with a black hoodie, one in a gray hoodie, began firing shots at the car. The witness also observed the car continuing to move until it hit a tree and ultimately stopped. He saw two of the males crouched behind different cars, shooting at the victim's car before the car struck the tree. The suspects then ran around an apartment building, approaching the stopped car from a different side, put on ski masks, and shot about 3 more times. Then they reached into the victim's car and took a black book bag and ran away. The witness did not realize until he looked at his security camera that there were actually 3 males that were walking toward the victim's car. The video shows the 3 males walking toward the car, but they don't show the shooting. Witness stated that he had seen the 3 males together before, walking around the apartment complex smoking. Detectives found 2 clusters of shell casings and a few shell casings near the victim's car. It appears the victim was shot at least 14 to 16 times, and there appears to be at least 2 different guns used. Detectives then met with the property manager, who provided additional surveillance. There are multiple videos, and they show the 3 males walking through the apartment complex, again, up to when they are approaching the victim's car, but not the actual shooting. On surveillance, suspect number 3, which the defendant has been identified, is seen running between buildings 615 and 621. And the surveillance shows after, I'm sorry, I messed up, Your Honor. Okay, on surveillance, the defendant is seen running through the buildings toward the end of the shootings, and surveillance shows after the taking of the victim's black book bag, the other 2 suspects are seen running in that direction as well. The apartment video surveillance goes on to show the 3 males going back to the breezeway of apartments 1 through 4. Surveillance also shows that after the shooting, 2 defendants, suspect 1 and this defendant, are walking through the breezeway. Suspect 1 is seen carrying what appears to be the victim's black book bag to the rear of the breezeway. Sometime later, the 2 suspects, including the one before the court today, are seen leaving together in a black Nissan, and they no longer have the book bag. Maintenance workers were able to identify apartment 3 to be associated with one of the suspects because about 15 minutes prior to the shooting, surveillance showed one particular maintenance worker working in that area, and he stated that he saw the 3 males together. A search warrant was obtained and executed on August 7th of apartment number 3. The apartment belongs to the defendant before the court, his mother. After showing still photos from the surveillance video, the defendant's mother identified her son, Jameer, as the person in the gray jogging suit. Additionally, when the defendant's room was searched, detectives found the clothing and shoes Jameer had on from the date of the incident. Jameer was detained, and his mother gave the police permission to speak with him. He was transported to headquarters to be interviewed. Prior to the interview, he was read his juvenile Miranda rights and he chose to speak with the detectives. He initially denied involvement, but ultimately confessed to being at the shooting, but not being the shooter. He identified additional co-defendants as Nardo and Trey. After speaking to the defendant, officers were able to determine a bit of a timeline of events because they were able to go through the victim's phone, and they also have received a number of Instagram messages. Detectives found the victim's phone in his car and saw that the last contact the victim had with anyone was a Telegram audio call minutes before the shooting, and it was from a particular user. The defendant appears in a message group with that person with that same username. Late night, July 23rd, which is the night before the shooting, and into the early morning of the shooting, the defendant is communicating with a now identified co-defendant, Nuruddin Amin. Nuruddin's nickname is Nardo, and Nardo was arrested this past Thursday, September 4th. There are messages going back between the defendant and Nardo about how many pens, meaning vape pens, they may get. Are they still doing that thing tomorrow? What time are they doing it? And how many of us are doing it? Through Instagram messages, detectives found messages from Jameer's account where about 4 hours prior to the shooting, he is sending messages to multiple people that he was going to TD, take down some pens, again, vape pens. Vape pens are being used for moho, some synthetic weed, and the victim was known to sell weed and have access to pens. Jameer is also communicating with someone and it's saying, we got to see when he's going to push up. Jameer is making FaceTime calls to the co-defendant Nardo and the third co-defendant, I cannot pronounce his name, Deviat Rakundo, who is nicknamed Trey, who was also arrested this past Thursday, September 4th. They were all communicating throughout the time prior to the shooting and after. Additionally, the day after the incident, July 25th, around 5:30 in the morning, Jameer is messaging with someone saying, we caught an N-word with his pants down. Then starts to talk about what appears to be the contents of the book bag, speaking about how many pens he now has, and mentioning a gun, which officers believe the victim may have had in the car while trying to sell the pens. This is a 14-year-old, Your Honor.
Swear in. Let's give us your camera on.
It says it is. Oh, wait a minute. Let me
There we
open
go.
it. There it is.
Okay, Ms. Givens, if you raise your right hand. Do you swear or affirm the testimony you give today will be the truth, the whole truth, under penalty of perjury?
I do.
Okay, and please state your name for the court.
It's Carmen Givens.
Okay, and Ms. Givens, if you give the judge some insight about what you think about the defendant receiving bond.
Good morning, Judge. I'm here today as a mother and an officer of the law, asking the court to deny bond to this defendant. I started my career working in DeKalb County Jail, where I witnessed, a lot of youth males coming in with serious charges and would talk to them, but some of them you can get through, some of them you could not. But having a son, I just felt like I needed to, try and talk to these kids to give them some insight on making better decisions and not, coming back and forth to the jail. But, today we're not here because of a mistake or a youthful error. The defendant, though he is a juvenile, he's charged with murder, which is one of the most serious crimes here in Georgia. This is not a lapse in judgment that can be excused by the age. This is the intentional taking of a life. By committing this act, the defendant has already demonstrated a capacity for violence far beyond what the society can safely overlook. The violent nature of this offense poses an undeniable threat to the community if the defendant is released. As both a mother who knows the value of a child's life and an officer sworn to protect and the public, I cannot ignore the danger he presents. And for this reason, I'm respectfully asking that you deny the bond.
Thank you, ma'am.
And Your Honor, just to close, the state does believe that the defendant poses a significant threat or danger to a person, to the community, or to any property in the community. This is the same neighborhood in which the victim lives. This was an incredibly violent, premeditated attack. The victim never made it outside of the car, but he was shot at 14 to 16 times on both sides of the car. And where the defendant had said that he was there, but he wasn't the shooter. At this point, the state we haven't been able to ascertain exactly who the shooter is. But what we do know from the evidence that we have thus far is that the defendant, at the very least, was part of the planning of this attack and also was trying to benefit from the fruits of the crime afterwards. Secondly, the defendant does pose a significant risk of intimidating witnesses or otherwise obstructing the administration of justice because, again, this is the neighborhood in which he lives. The only witnesses to this crime are neighbors and workers of the apartment complex. So if the court were inclined to give any sort of bond, the state would request that he not live in the place where the incident location was. So he would also need probably another supervising adult.
Attorney Schlissel, do you have any questions for Ms. Gibbons, first of all?
I'm sorry. No, thank you. I'm sorry for your loss.
Thank you, Ms. Gibbons. You can turn back off your camera and go back on mute. Go ahead, Attorney Schlissel.
Thank you, Your Honor. Your Honor, Jameer, as was stated, is 14 years old. He resided, prior to his arrest, he was residing with his sister, a 16-year-old, 11-year-old sister, a 4-year-old brother, a 3-year-old sister, and a 2-year-old brother. He was just about to start Stone Mountain High School in 9th grade. He has not had any prior contact with the juvenile justice system. He has not had no prior arrests and has not had significant behavior issues at school, as far as I know. He was actually the following day was about to have a physical done so that he could try out for the football team at the school. Your Honor, he has intentions of going to college after he graduated from high school. His mom explained that he's extremely helpful in the home and the neighborhood. He would help taking out garbage for neighbors, and he was also working at a barber shop helping sweep up the floor and other little things that they needed help with. Your Honor, we would submit that based on the Ayala factors, he is not a risk to a flight. His father and family all live here in Georgia. He has no prior history and would be able, if the court would consider granting him a bond. His mother has identified his maternal grandmother who lives in Atlanta away from this neighborhood because his mother also does not want him to return to the apartment complex where all this happened and where these other youth and their families also reside. So we would also be in agreement with no contact, as well as not returning to that area. Your Honor, we would be asking for a bond in the amount of $25,000 based on the Ayala factors. And at this stage, there is no indication, although it sounds like there's some indication that he may have been involved in some intention to commit a robbery. There's no indication that there was an intent to commit an armed robbery or for him for his participation in the shooting specifically. But as again, as for the all factors, we would be asking for a bond in this matter. Thank you.
At this time, the court's going to find that he's a risk to intimidate witnesses and a danger to community and persons and deny bond.
Thank you, Your Honor. That is my business, my big excuse.
Yes, ma'am.
Okay, friends, yet again, another kid throwing away his life. You guys know how I feel about that. Big friggin' surprise, though. We see it every day, don't we? We got about 10 minutes left. Let's get out of this drab dreariness and go to maybe a different kind. Let's go to Judge West. She's usually not drab or dreary, but it is Monday, and people tend to let her down on a Monday. So let's see what's going on.
Good morning, sir. You're Jose Contreras. And will your client waive the formal reading of the indictment? That's for Anna. That's Mr. Contreras, in cause number 25 DCCR 0006, you're charged with the state jail felony offense of failure to comply with sex offender registration requirements, and that's from June 13th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Speak up.
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Contreras is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, we'll see you back at sentencing. And then, Mr. Parker, you have Jeremiah Davis.
Your Honor.
Oh, that looks like I'm signing a dismissal right now. Is he here? Jeremiah Davis?
I told him to wait outside for me, Judge.
Okay, you can let him go.
Okay.
Let me sign that. And then you have Lamira Henry. It's a sentencing.
Henry.
Good morning. Let's see, this is, let's see, I think Mr. Smith on Lamira Henry. Good morning. Good morning. And so Ms. Henry was previously in court in cause number 24, DCCR 1668, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir.
Are there any additions or corrections?
No, Your Honor. Not from the state.
Ms. Henry, I've got some real concerns about your criminal history. You've been very busy in Louisiana, haven't you?
Yeah,
Yeah,
that's my past.
that's your past. Well, your past isn't that long ago on some of these. Some of them are old, some of them are not. And so I want you to understand that if I go along with this agreement and put you on this probation, that you will be on 0 tolerance. That means you cannot miss an appointment, you cannot test positive, you cannot do anything that's a violation of your probation, or you will be in here on a motion to revoke your probation. Do you understand? All right, okay, then I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made. Find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're on probation. The other side of that, though, is that you've already agreed to a 10-year sentence. So any violation of your probation could end up with that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Oh, wait, I have to hand you one more thing. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or how long that lasts, you can talk with Mr. Parker. Okay? So have a seat here in the courtroom, and probation is going to call you up when she's ready to go over your paperwork. Thank you. Good luck to you, ma'am.
Okay, friends, another person being put on a 10-year probation, and we know the odds of that succeeding. So, unfortunately, despite her deal to avoid 10 years in prison, I doubt she'll make it because they just don't make it that long. I don't know why they keep trying it. It never works. But, you know, whatever, I suppose. It's time to call it a day, though. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. If you're not a channel member, you should become one. Join us on the pre-show. It's fun. It's whack. It's crazy. It's funky. It's all those things and more or whatever. But yeah, join us tomorrow. Go make yourselves a good Monday. I know a lot of you out there are talking about coffee right now because you're having such a hard time of things. Go make yourself another big coffee. Make the most that you can of today, and we'll see you tomorrow. In the meantime, take care. God bless.